Good morning and welcome to Estate Planning Nightmares, how to avoid the scary mistakes that haunt families. I'm Eric Brotman from BFG Financial Advisors, and we are so glad that you're here today. A couple of housekeeping notes real quick. If you have questions, there is a Q&A box at the bottom of your screen, and if you click that and put a question in the queue, Sarah Losi, who's behind the scenes today, will be very happy to either interrupt us mid slide or to hold it till the end so that we'll have some time for Q&A. I want to make sure we make all the lawyers happy with that, and now I'm ready to move on. So just by way of introduction, for those of you who don't know me, I'm the CEO of BFG Financial Advisors in Lutherville, Maryland. I've been doing this for 32 years, and I'm actually in the process, talk about scary Halloween stuff, in the process of handing the CEO reins over to Lena Nebel. We're going to be talking a lot about that in the next couple of weeks. It's a very exciting time for our firm. And I am pleased to be joined by Amanda Plant. Amanda, if you would introduce yourself so everybody knows who you are. And yes, we are hosts, not ghosts.
Thank you, Eric. Hi, I'm Amanda Plant, and I'm an attorney at the Eris Law Group, and I practice primarily estate planning.
So, how was your Halloween?
My Halloween was wild, Eric. I have a 10-year-old. He had a friend
Mm.
come over, and him and all the neighborhood kids just ran wild. We have a ton of really cool Halloween decorations in my neighborhood. There's at least two giant pirate ships where people just go all out. Some people
Wow.
out of bushes at the kids. It was quite entertaining.
Well, all right. For the record, I don't want that, but I think that is fun. Did you wear a costume? Last question about Halloween.
I did not wear a
You
costume.
did not. All right. Well, I'm not going to ask what your son was, but that's fine. My daughter's a little old for that. She did go trick or treating a little bit with some friends. I did not get a Snickers bar, which is really all I wanted. But she did not share with me. It's very sad. All right. Let's start with a poll. And Sarah, do you want to walk us through how the poll works? This is the first time we've done one of these. All right. On your screen, you should see a question that says, when did you last update your estate plan? Was it within the last year? Was it 1 to 3 years ago? Was it 3 to 5 or more years ago? Or don't tell us, but I don't have an estate plan. We are collecting votes now. We're going to give it another 30 seconds or so. These are anonymous, no shaming. All right, Sarah, do we have some answers to share?
We do. It looks like all right, you guys are in trouble a little bit because
Well,
50%,
let's see.
60% said they do not have an estate plan.
60% do not have an estate plan.
And then
Okay.
there are a few that did, update within a year, and then, a few that it has been 3 to 5 or more years.
Okay. Well, 3 to 5 years, not terrible, but not having an estate plan, I think we're going to talk you into having at least a basic estate plan within the next 45 minutes. But thank you all for your answers to the poll. We're going to share some scary stories today in the spirit of Halloween. And I know Halloween's over, but you're all still in that sugar coma, so let's do it. And we have 6 chapters to share with you, 6 scary stories. And Amanda and I are going to take turns sort of kicking these off. The first one I'd like to call death and taxes, which, as you know, those are the two things that we can count on forever, are death and taxes. And this is a story about life insurance that becomes a serious estate tax problem. And so a little bit of detail. When you own a life insurance policy, even a term life insurance policy with no cash value, um, if you own a policy on your own life, when you pass away, the death benefit from that becomes a part of your taxable estate. So whatever let's say your net worth is $3 million, but you have $4 million of life insurance. Now you have a $7 million estate. Now, not everybody has estate tax issues, certainly not federally, but at the state level, every state being different, you do have to concentrate on what some of those limits are and how that plays out. So if you have significant life insurance, a little bit of planning around how it's titled, how it's owned, how it's being paid out can save a serious tax problem. So, as a part of your estate planning process, what I would suggest is that we make sure that the death benefit from any and all of the life insurance on your life or your spouse's life or partner's life or even business partners' lives. This has become quite a hot issue right now in the Supreme Court. But it might mean titling some assets differently. It might mean titling or owning life insurance differently. And of course, one of the great solutions is to move to a state that doesn't have an estate tax. But assuming you like where you live and you don't want to move, those are a few of the things that are available. There are life insurance trusts that you can own that will allow life insurance, if it's done properly, to be outside of your taxable estate. And so while we can't prevent death, we might be able to prevent death taxes. Amanda, thoughts?
Absolutely, Eric. I've seen this happen probably one too many times, especially in the area where I practice, and specifically DC. Virginia, not so much. Maryland, yes, DC's the big one there for estate taxes, mostly because they have the lowest limit and no portability. Um, I I would wonder, Eric, I've seen a number of times, where sometimes people will take out, a couple will take out, like, the second to die policy,
Mhm.
with the idea being, I believe it's a cheaper premium, and their plan is that's actually gonna pay the taxes that they're, gonna owe on their other assets. Is that something you might recommend?
Well, sometimes, although I would make sure that you didn't own it in your estate because all you're doing is compounding the problem. So if there is a need for liquidity, and the reason people use survivorship life insurance, which is life insurance on two people, where no death benefit is paid until both people are deceased, the reason to have a policy like that is to create liquidity, either to pay estate taxes or sometimes just to equalize inheritance. If you own a family business and you have two children, and one of your children is going to take over the family business and the other one is not, and you don't wanna leave the assets in a way that is sorta 90%, 10%, you wanna try and equalize that inheritance, you can do that with second to die life insurance. You just make sure that it's owned in a trust, that there's an independent trustee, and that it does not compound your tax problem in DC or Maryland especially, but even federally if the numbers get big enough. I would also say that there's a tendency for married couples and spouses to have all of their assets jointly titled. And there are reasons why that may not be the best tax strategy, because it creates survivorship, but it also eliminates the use of part of a tax exemption. And I don't want to get super technical, but I will say that if all of your accounts with you and your spouse are jointly titled, there may be easy ways to solve what could be a lurking tax problem and kind of a scary story. Shall we move on to the second topic? All right, let's do it. It's your turn.
That's
It just
me.
looks scary. Yeah, go for it.
The business that died twice. That sounds bad.
It does sound bad.
I know. This is actually a situation that I dealt with. I helped out some of the parties who were part of it. It was DC because DC has some funny laws about. Well, all states have funny laws about if you die without a will or any type of estate plan. But DC has some of the oddest, I will say, for who actually inherits by default law. In this situation, it was a partial business owner who passed away unexpectedly, very young. It was a very sad situation, and left behind a spouse and a minor child. The problem here was he had no documents at all in place. And in DC, without any planning, if you pass away with children and a spouse, it gets split a third to the children and two-thirds to the spouse. That's if the children are of the marriage. It's 50-50 if they're not. That's unlike other states like Virginia, where it would go 100% to the spouse in that situation.
Mm.
So here we had a third of his estate going to a 3-year-old and the remainder of the estate going to the spouse. Well, this caused a number of complications, not only on the probate side, that's the court process for distributing the assets, but also just for the business itself. He was a one-third owner of this business and they couldn't operate. The court kind of took over and was dictating what this business could do because they also didn't have some operating agreements and other things a business should have in place. But it took months to even get this to a point where they could operate, and I'm sure they lost a lot of revenue. So Basically, we had a business that was owned a third by a 3-year-old who was then controlled by the court.
Oh, well, what did the 3-year-old lack business acumen? Is that part of the problem?
I mean, I think she had a good handle on it,
Oh,
but I
good.
think she was too busy, in preschool, handling that and some, like, friendship things and, just didn't really feel like running a business at that point in time in her life. This one had some other complications where there was, like, valuations of the business because they didn't have any documentation in place for that. There was estate tax problems, not estate tax problems, but there was estate tax complications, due to the value of the business as well as, what you just talked about, Eric, some large life insurance policies. So, all those individual had done some things by getting, like, life insurance and, that type of thing to take care of his family. He didn't take the next step, to, have a plan. Even a basic will would have alleviated half of the issues that they experienced.
So, a couple of things to unpack in this case. Number one is estate planning, which is done at the individual level and usually within the context of a family dynamic, is also something that needs to be coordinated with business planning. So, I am a partial owner of BFG, and at the end of the day, my wife and daughter will never be owners of BFG stock and therefore be controlling members of our board of directors or anything like that. We have done all the documentation that we need so that my family will receive the proceeds for the value of the shares that I own, but they will not wind up being shareholders of the company. And we've done that for all of our shareholders. And businesses can do this. You just have to have you need the right counsel. This is not just the right estate attorney, but often it's the right corporate attorney. And it makes sense, I think, Amanda, to dot I's and cross T's because some of these mistakes can be huge. My daughter is also under 18 and also is more into musical theater than personal finance. So I don't know that she should be running this company at any given point in time either. Anything else to add on this? I mean, obviously, the key here is that dying without a will in almost any state is a serious problem, particularly if you have children, particularly if you have children from multiple marriages and all the things that make the family tree more like a shrub these days. But beyond that, not having the right business planning can also play a role. Anything else on this one?
No, that's pretty much it, and you're right. You're right, Eric. You need the basic estate planning for yourself as well as the business succession planning. And I would say this was a large business, but it's 3 owners, but it was a, very profitable business. But this is true even for like single member businesses. I know I've dealt with, issues where even the business didn't generate a lot of money because the business is still alive even if you've died.
Indeed. And as a business owner myself, that is part of the legacy that I intend to leave behind long after I'm gone. And that means doing the right planning. Let's move on to chapter 3 of our tale today. And yeah, as I mentioned, I have a teenager. You don't yet, but you're in for a treat. I have a teenager, and the teenage transformation is that moment where a child reaches the age of majority. And in some states in the US, it's 18, at some it's 21, but generally we warn people prior to 18 that this is something to be thinking about. And what happens when a child turns 18, and I'm going to use that as the broad brush, is that there are no longer parental rights to do almost anything with this child. So, I mean, if you've got a kid in college, you can't even request your child's grades because your child's an adult and has to give permission to share their report card with you. It doesn't matter who's paying the tuition, of course. But what it means is you can't make financial decisions for your child. You can't make medical decisions for your child. And so when people are 18, they really need to get basic estate documents right away. And I know that's not something that most people think about. Most 18-year-olds don't need a will unless they're, become parents very young or have gotten married very young. But generally speaking, a will is not the issue. The issue is the financial power of attorney and the advanced healthcare directive that can name one or both parents as the person who can speak to a physician if your child's in an accident or gets sick, or can speak to a bank or other financial institution to help your child do the types of things that they need to do. This feels like a very easy best practice. So, for any parents who are watching, getting really simple powers of attorney for the financial and healthcare directives for the medical can make a huge difference because if you have a 15-year-old in an accident, you can go in and speak to the doctor as that child's parent. If you have a 19-year-old in an accident, you can't. And so it's important that that you continue the ability to be a parent and a guardian, assuming that's the right family dynamic for you. Anything else to add on this, Amanda?
Yeah, I mean, Eric, I would add that a slight plug for myself, but we have actually offer college student packages that prepares all of these documents as well as the ones for releasing the grades to the parents. So
Oh,
yeah, the package is the power of attorney, medical directives, and the FERPA release. So those are pretty much usually what the college age students would need. I will just a slightly different scenario, but sometimes when a child has special needs and is never going to be able to manage their own affairs. A bigger thing to look at in those types of situations is you're doing these things for your child until they're 18. The minute they become 18, you don't have the power to assist them. This is for incapacitated individuals who cannot manage their own affairs. And in those types of situations, there's a lot of planning that needs to be done. But on the side of when they're going to turn 18, we can start the process of appointing a guardian because we don't want a gap there at all.
right.
About 6 months before they turn 18, paperwork can't be signed and stamped by the judge till the 18th birthday, but we kind of have it all prepped and ready so that the day they turn 18, we were able to get that in place.
I'm glad you brought up special needs because it's not something I think that we were going to spend a lot of time on today, but I think it's really important that for children who become of majority age, as you mentioned, the parents don't have certain rights without having them reduced to writing. But in addition to that, it's really important for any young person or any person who is getting some form of government assistance or other things not to have assets in their name and not to be beneficiaries directly on any of mom and dad's accounts, or to make sure the grandparents or the aunt and uncle or the friendly neighbor don't accidentally leave money directly to your special needs child because it can create all kinds of financial issues. There are special needs trusts that can be created that will allow for assets to be held for your child or your beneficiary's needs without having them in control of the assets and without belaboring the point. Just if you're in a position where you have a child who's unlikely to be able to care for themselves fully at a given point, and you're concerned that your family members might be leaving money to that child just to be benevolent, they can actually be doing more harm than good, and it means having a family conversation. And we have lots of those conversations with our clients. I'm sure you do the same. But because you brought up special needs, I thought the age of majority and special needs have some things in common, where suddenly the legal system assumes that these folks can make decisions for themselves, and maybe they can, and maybe they can't.
Yeah, absolutely.
Let's go to chapter 4. It's getting scarier. I don't know how I feel about this one, but it's your turn.
I will say probably the most conflict we see in estate planning, or not estate planning, I guess, probate or after you have passed away, it revolves around beneficiaries. Um, I had this one situation, and I think this happens more often than not. And this is a good reason why those of you who have estate plans, fantastic, but you haven't updated them in a while, you should probably take a look at, who's married, who's divorced, who's been born, who's passed away, who no longer is, in your life, in order to update those plans. But this situation it was basically a bar exam, like nightmare type question that I had
Mm.
here. But this individual drafted a will, fantastic. She named her sister as her beneficiary, and that was that. She then got married. And her spouse kept everything separate. They didn't have a prenuptial agreement, which is also a good thing to have, but I won't get into that topic. They didn't have a prenuptial agreement, but they kept everything separate, and there was a later in life marriage. So the intention was that everything was still, for the most part, going to go to her sister when she passed away. The mistake was she didn't update her will. And this was, in Virginia, but every state has some type of rule where you cannot completely disinherit your spouse. absent a prenuptial, postnuptial type agreement. And so in this situation, the spouse was considered a pretermitted spouse, which means they didn't exist when the will was created. And so under Virginia law, they're entitled to 100% of her estate.
Wow.
And that was certainly not what she intended to happen. But that's I mean, there's some things that happen, and they didn't get 100% of the estate. But that did require a bit of litigation, a lot of settlement, a lot of time, a lot of conflict, and there was there was heightened feelings going on between the sibling and and the spouse as well. There is a bazillion ways to avoid this, prenuptial agreement, postnuptial agreement, making sure you update your will. We can even do this with trusts where you give a certain portion to a spouse, but it's held and eventually goes to, to other beneficiaries when the spouse passes away. So Eric, I don't know if you have anything to add or if you've seen this type of situation happen before.
Uh, uh, beneficiary designations are so important, and people, I think, don't remember to adjust them even when there are major life events. I started my career when I came out of college. I was working in the legal department. I don't know if you even know this, Amanda, but I was working in the legal department for a brokerage firm. My plan was to go to law school and do estates and trust because what you do for a living seemed fun to me at 21. And at any rate, I was the person who got the phone calls when a client of that firm had passed, and I can't tell you how many times I had to explain to someone, "Ma'am, I'm sorry that your husband passed away, but his former wife is still his beneficiary on his IRA or his life insurance or his stock account or other things." And what people don't understand is your will could be absolutely perfect, but if your beneficiary designations on your employee benefits, on your life insurance, on your IRAs, on your qualified plans, on other things, if the beneficiary designation is different than what's in the will, the beneficiary designation takes precedence. Because, in other words, if there's a beneficiary named on an account, it passes before it gets to the will. So if you have a situation where you're married or divorced or you're having kids, what people will do is they change jobs and they sign up for things and they name their spouse and their child as beneficiaries, primary, contingent, okay, fine. But then they have 3 more children and they forget. I mean, their will might be drafted to say, if I have future children, include them, but the beneficiary designation names just their firstborn. And so, unfortunately, there's a lot of situations where, younger siblings or others are accidentally disinherited. And what's in the beneficiary designation absolutely supersedes the will in basically every case. I think it's called operation of contract or operation of law, as opposed to, not that I went to law school. I'm not practicing law without a license.
Go to one.
Thank you, thank you. That's about as much law school as I'm going to share today because I didn't go. All right. Now, the next piece of this is that there are two little words, and I don't know a lot of Latin, but there are two little words that make a giant difference in a beneficiary designation, and those are per capita versus per stirpes. And again, not a lot of Latin, not since seventh grade, amo amas amat. But if a beneficiary designation is per capita, it means it's per head. If it's per stirpes, it means it's per root. Here's what that means. Grandma has an IRA account. It's worth $1 million. And she's leaving that IRA to her 2 children who are grown and have their own children. So let's say it's Eric and Amanda. We're the 2 kids, you and me. And we each have 3 children, hypothetically. If when our mom dies, you and I are both alive, per capita would mean we each get 50%. Per stirpes would mean we each get 50%. We're both alive. The problem is, let's say that I've predeceased. I died before mom. I left 3 children, 3 of her grandchildren behind, and you're still alive and well. If the beneficiary designation is per capita, you will get 100%, and my children, her grandchildren, will be disinherited by one Latin word. If it says per stirpes, you'll still get the 50% you were expecting, but my 3 children will equally share the 50% that was set for me. And so this simple word can change everybody's life and preserve or destroy Thanksgiving. I know Halloween is over, Thanksgiving is coming. You can destroy Thanksgiving for generations of your family with one word. And it happens, and usually it's an accident. So when you're going through sort of the takeaways from today and you're thinking, if you don't have an estate plan, let's get one. And if you do, let's make sure it's right. Regardless, make sure you know who the beneficiaries are on every account you have that has one. IRAs, Roth IRAs, health savings accounts, life insurance policies, other employee benefits, maybe business agreements, you name it. Because unfortunately, I used to see that a lot. It's actually one of the reasons why I do what I do for a living, Amanda, is that I saw so many people who I couldn't help that I decided to get on the front end of that. And so that's sort of how I wound up as a young 20 something getting into this business, because I realized these are simple fixes that people don't know and we can make a difference. So, anything to add on beneficiaries?
Uh, the only thing I would add on to beneficiaries, has to do with joint ownership of accounts. If you own account jointly most of the time, and I want to say all of the time, and somebody passes away, it goes to the other joint owner. That's usually what people want. But I have seen it, I've certainly seen it probably more often than I feel like I should, where somebody still owns an account jointly with a parent because they opened it when
Yeah.
they were 15 and they never, never changed it. And it's like their main account. There's a ton of money in it. And they're now married, have children. And so that's certainly not what they would want. And that's not what the parent would want either in that circumstance. So check your ownership of accounts, see how they actually
Yeah.
are owned and by who.
Yes, there are lots of different kinds of joint ownership. What you're talking about here is joint tenants with rights of survivorship, or for married couples, tenants by the entireties, which some states allow and some don't. That's where you have survivorship of the one or more joint owners in the absence of one of them dies. There's also a joint ownership where it's tenants in common, where you share an account, but your portion goes to your estate. There's a lot of technicalities here. But Amanda, you're right. This is something to double check. And if you are doing the planning for your aging parents and they want you involved, and we're going to talk a little bit later about power of attorney and ways that you can be involved and be their agent and help them without being on their account and actually being joint owners. If you're a joint owner with mom or dad and you have siblings, and the plan is, I'm going to take care of mom and dad because I'm local and I'm doing the banking and the investments and all that, so we'll just make it joint. When that person passes, you inherit the full account. You can't just say, "Oh, I'm going to share it with my siblings," because that could be a taxable gift between you and your siblings. It needs to be done in advance. And I know we're going down a road that now we've got everybody scared to death. So Halloween was the right theme for this. But these little things matter, and really having them looked at forensically is very, very important. Let's shift gears, and I'm going to ruin Thanksgiving again, because why not? I want to talk about the haunted house. Um, this is a case, and we see this a lot, where mom and dad own a second home, a vacation home, a lake house, a shore house, a mountain home, whatever it is, and they're going to leave it behind to their family because the family has been going there every fall, every summer, all the time. And that's where memories are made, and it's a wonderful, wonderful thing. The problem is, mom and dad leave this house, this lake house, when they're gone, to their 6 children. Now their 6 children own it equally and have to take responsibility for it. They have to pay maintenance costs for it. They have to pay taxes for it. They have to decide who's going to get to use it. And in some cases, there's disagreement about what to do with it. You might have one of your kids who says, I want to live in this house. And you might have one or two who say, we want to use it for vacations and still use it whenever we want. And you might have 3 kids who say, we want to sell it. We need the money for other priorities. We've got to educate our kids, or we've got other things. We want to sell the house. And what you've done accidentally is created massive conflict by lack of communication in advance. And you can literally damage families over what was designed to be a legacy and a gift and something meaningful. And I'll throw another wrench in there is, if that property is owned in any way such that it's per stirpes ownership, and you leave it to your 6 children, when one of them dies, 3 grandchildren from that end will become a partial owner of this property. And you could have 10 or 20 owners of a piece of property at some point, and they all have to agree or vote on various activities, and it literally is a family feud. So if you have a property like this and you want to leave it behind to your heirs, which is a lovely, amazing thing, having communication in advance matters. determining what those heirs would like to do with it. If you have one who wants to own it, maintain it, pay the taxes on it, and so forth, you can leave the house to that heir and use life insurance or other assets to give to the other kids. It's perfectly fine. You don't have to leave everything split equally. If you want to leave an equal inheritance, you can do it with different kinds of assets. And there's lots of reasons to do that from a tax standpoint, from a benefit standpoint, from a liquidity standpoint. Um, but I would just say that it's important to understand how the kids feel about this property in advance, because if they can't agree, you're better off either selling it during your lifetime or having your personal representative of the estate sell it and split the proceeds amongst the kids equally and let them decide what to do. And I know that stinks if this is something you wanted to be in the family forever. Um, but sometimes that winds up being the right answer anyway if the kids can't agree. You really don't want a family feud. Thoughts?
Absolutely. I mean, I think planning for a house, whether it's a vacation home or even your primary residence,
Mm,
is important. I mean, there's Virginia's weird where it drops like a rock, everyone just owns it. But you don't want that to happen. You don't want 5 kids to own your primary residence. Then they all have to get together to try to sell it, and it's this hassle. Whereas you could have had it pass in a much simpler fashion.
yeah.
Or you have what happens in, I don't know if DC is unique in this, but I've seen this happen a number of times in DC where, somebody, the owner of the house passes away, the family, various family members, live in the house. They continue to pay the taxes. Nobody realizes that this person's passed away. 20, 30 years go by, they wanna sell the house, and now we have to figure out ownership because people have died in the interim, and it's owned by all
Yeah.
kinds of people all over
Yeah.
the place, maybe 20, 30 people, distant cousins, that type of thing. So houses can be a real nightmare, and then they just sit, and
Yeah.
that's unfortunate.
Yeah, you're absolutely right. In these cases, I'm often thinking about that family vacation home. But you're right, a primary residence. If you pass away in the family house where your kids grew up, and you leave it to 3 of them, and one of them wants to move in, and one of them wants to sell it, and one of them wants to rent it, you've got a new problem. And you're absolutely right. If you don't say anything and you just pay for the taxes, then you're just postponing and amplifying a problem. So, I guess if there's a remedy here, it's communication, and that's true for all of these scenarios. It's having some communication with your loved ones, with your family, with your legal and financial counsel and your tax people, with all of it being as transparent as you can. And a lot of parents are nervous about sharing their financials with their kids. Partly because if they're worth a lot of money, they don't want their kids to lack work ethic, thinking they're just going to sit there and wait to inherit, which unfortunately is something humans sometimes will do. It's okay to be transparent with ideas and with qualitative discussions without talking numbers. You don't have to talk about necessarily what a specific thing is worth to say this is how I'm thinking of having it handled, or what would you three like to do with the house if something happens to me and your mother, or whatever it is. So we're on our last story, and these always get scarier as we go. So there you go, a tombstone with no name on it. It's very sad. Your turn, the powerless spouse.
I mean, I think there's something that people don't understand in general, about, like, rights, of if something were to happen to you, and that's where the power of attorney comes in. Um, nobody, nobody at all has an automatic right to access your accounts or make legal or financial decisions for you, even if you have a spouse. Now you might say, "Oh, yes, they do. Yes, they do." Sure, they can pretend to be you. Sure, they have access to
Mm,
a joint account, but I'm talking about
mm,
I know, pretend to be you. But I'm talking about, individual accounts. And Eric got a little into, powers of attorney and adding people to accounts and that sort of thing. You generally do not want to add someone as a joint owner of an account if you want them to assist you with managing it. If the point is the account is yours and it's shared, that's one thing. But if it's you're helping out that parent, or anybody else, you want to add them as an authorized user, which is possible sometimes, or you want to get a power of attorney, which is more of a general grant of authority that allows you to, manage legal financial affairs. And I think the other thing that I see, and I'm sure you see this often, Eric, in your line of work too, is this has to do primarily with couples. Usually one couple, husband, wife, husband, wife, husband, husband, whatever it is. One of them manages the money. And the other one usually doesn't really know what's going on. That happens quite a lot. And I had a situation, this was fairly recent, where the husband in this scenario managed all the money, had all the accounts. The wife knew nothing about at all. And the husband had a health crisis, was in the hospital for weeks, didn't have capacity, couldn't really communicate. The wife didn't have access to the accounts. I think she had access to one joint checking account. She couldn't pay the mortgage. She couldn't pay the credit card bills. She had absolutely no idea where anything was. And the minute she, figured out, oh, there's something at this financial institution, they wouldn't talk to her because she didn't have a power of attorney. She wasn't she wasn't on the account. Now, this couple, and I would encourage all couples to have a conversation. It is perfectly fine if one person handles the finances. That's always going to happen. There's someone who's going to handle the majority of that, but both should know where everything is, and there should maybe be a binder in your house or something like that. Now, just very quickly, this nightmare turned out to be okay. He did regain capacity enough to sign a power of attorney. She was able to gain some access to accounts, and he actually is doing quite well at this point in time. But it wasn't good for a number of months. I will say that here, and I've seen this happen probably multiple times, even just in the last year, something similar to this.
I will add, first of all, you're 100% right. This happens a lot, and I do think it's important for married couples to have power of attorney naming each other as the attorney in fact, but then making sure they have a second and third person because sometimes they're in the same accident. You want a second choice, a third choice. I'm going to throw something in here that you might disagree with, and that could be fun. We could have a debate, but I tend to believe on power of attorney documents and healthcare directives that it's better to name one human than multiple humans. Some people want to name their three kids to handle their affairs, and my fear is a lot of times, first of all, we're creating complexity, but secondly, those kids couldn't agree what movie to see. They're not necessarily going to agree on all the big financial or medical decisions. So I tend to encourage people to name one person, and if that person is one of several children, to specify that please, to the extent you're able, confer with your siblings prior to doing this, but ultimately the buck stops with you. And oh, by the way, communicating that to your kids so they know, yes, I'm naming your brother as a medical power of attorney because he's a nurse, and I'm naming your sister as a financial power of attorney because she's a banker, and that's okay, or because one of them is local, or because it doesn't have to be the oldest. I mean, in our family, fortunately, it is, but generally, it doesn't have to be the oldest. And so I think that's pretty important. And if you feel otherwise, you feel like, oh no, you can name three and any can act. I just worry about situations where they don't agree. And I think of the Terry Schiavo case,
Oh,
which is now 20 plus years ago, but it still scared me straight in terms of how to do this planning. If you have a medical crisis and doctors are ready to advise to do what could be life ending type of things, and you have two people there, you have a spouse and a kid, and the spouse is saying, My wife wanted me to pull the plug," and the kid is saying, "Don't you do that to my mom, don't you dare," and there's no documentation. The physicians literally can't act. There's going to be litigation, there's going to be a court involved, and it will not only destroy the family, it's potentially going to keep somebody in medical limbo for what could be a very long time. None of us would want that for ourselves, I wouldn't think. And so, just whether it's the financial or the medical, it's just so important to have somebody ready to step into your shoes. And unfortunately, here's the other piece. We talk a little bit about leaving money behind to kids, Amanda. We can't control who our children marry, or if they have kids, or how their kids turn out, or if they ever get divorced, or any of those things. And so I think doing some trust planning when you've reached a certain level of wealth, and I don't need to quantify that, but if you've reached a level where you're concerned about how assets might be handled, um, I think it's really important to consider some trust planning to protect your kids from predators and creditors. And that could be a terrible ex-spouse. It could be a kid with a gambling issue. It could be any number of things. Life happens. It's messy. But doing things to keep as much, not control beyond the grave. This doesn't have to be creepy, but to protect your kids from themselves. They don't always know exactly how to handle these things. So I'm a little off topic. Call it chapter 7. But anything else to add to this before we start talking about how to banish these ghosts from our home?
No, and Eric, I actually don't disagree with you about who to name as, the power of attorney or how many people to name. I think you should name a primary and at least one alternate. You can name
Yes.
as many as you want, and it's not a bad idea. Now I have seen that where they want to name all of the kids. Sometimes we'll have a conversation about it. Sometimes we'll even say, okay, if there's a disagreement, this kid makes the decision, even though they're all kind of named. Still that kid's in charge, but they feel better about it. And I do think it's important. I've had this conversation with clients as well as family members is don't necessarily just name the oldest child or in that
Right.
order. That doesn't
Right.
make no sense. Maybe somebody is better in that area, or maybe somebody is local, and that just makes more sense. But the
Yeah.
key there is communication. As long as you communicate, with the children and explain, then hopefully, no one will be, feel hurt or left out.
So I want to take a quick tangent here because we've talked so much about powers of attorney and healthcare directives and wills and beneficiaries and assets. And we haven't talked about guardianships yet. And I think it's really important when you do a will, if you have children, minor children, when you do a will, you have to name someone typically to be the trustee to take care of your minor child's assets, but also you have to name someone to be guardian to take care of your minor child's person. The person who takes them to school and makes them lunch and they live with and takes them to the doctor and essentially becomes the legal guardian. Um, and you talk about who you name for these various things. These are huge responsibilities. And, most people wanna name a family member, but you really have to consider the condition in which that family is. If you name your sibling, to take your 3 children on suddenly, and your sibling is a crazy roaring single in Manhattan somewhere and has never been a parent for whatever reason, that may not be the best person to handle suddenly having 3 children. Some people are really great with kids and really lousy with money. Some people are really great with money and really lousy with kids. The guardian and the trustee don't have to be the same person. And lastly, and then I'll let you jump in. I think it's really important to try when you name a guardian for your kid, don't name a married couple. Name the one person because if you name both and they're not married anymore, now you have a new problem all of a sudden for your 7-year-old. And so there's a lot of nuance here, and this was the 45-second version of a 20-minute conversation probably, but anything to add on guardianship and trusteeship for minors?
No, I mean, that's probably the conversation I have most often is say they don't have to be the same person. You name the person
Sure.
best suited to care for your kids, guardian, person best suited to manage money as the trustee. Of course, there's gonna be a lot of interaction. Well, any children are minors.
Yeah.
So hopefully those individuals get along to some degree.
Yeah.
But it can absolutely be different people. And I mean, from a statistical standpoint, and this isn't, don't hold me to this number, but I think it's about 65% of the time people name the same person in both roles. But
Mhm.
you still have about 35-40% where they're naming someone different.
Yeah.
So it's certainly not uncommon either way.
You also have to review it. I mean, if you have a newborn and you name one of your parents to be the guardian or trustee, and that parent is 70, that might be fine. But suddenly you have a 10-year-old and that parent is 80 and maybe not the right person anymore, or maybe isn't even living anymore. And so you have to adjust those things when you adjust your will and you adjust your estate documents to make sure that the people or persons you've named are still not only living, but competent and capable and willing to take on that responsibility. There's some 80-year-olds who love their 10-year-old grandchild, but might not be the best person to handle their day-to-day affairs, for example. So, well, let's turn the page here and let's do some ghost banishing. You're now Bill Murray, I think, which makes me Dan Aykroyd. We're ghost busting. And let's talk about the things that folks can walk away from this webinar with. We'll talk about a couple solutions and best practices, and then we'll open it up to questions. If you have questions, there's a Q&A box at the bottom. Sarah is going to gather those, and she's going to put us on the hot seat. So anything that comes to mind, please ask. And if you're watching this not live and you're watching it recorded, we'll give you our contact information so you can ask us questions one-on-one if you prefer not to do it publicly and so forth. But let's talk about these various things. And I think the first one, if we haven't beat the heck out of the first, probably two, shame on us. What does current mean to you, Amanda? How often should people review these, assuming there's no major life change? I mean, obviously, you get married, you get divorced, you have kids, somebody dies, you review these things. But if nothing material has changed, what's current as far as you're concerned?
What I usually tell people, when they just finished their estate plan, is make sure you look at this every 3 to 5 years. I'd like to say annually, but I wanna be realistic there about 3 to 5 years, and if
Yeah.
there's any life changes. Those are kind of the two things. And, even if you're looking at it, every 3 to 5 years, after 3 years, that doesn't necessarily mean you have to engage with a, attorney or other professional. You can just look at the documents yourself, and be like, yeah, that makes sense. That nothing's really changed. Of course, you can always engage with an attorney to, go over it with you to make sure there wasn't some little nuance, that's possibly changed. But really, it's just like take a look, see who you named as your fiduciaries, see who your beneficiaries are, see, like what's happened. Maybe, now your parent is in their 80s and they're not going to be best suited in that role, so we need to make a change. Maybe someone's gotten divorced. Maybe there's you have a bunch more nieces and nephews that you want to account for. There's a lot of little things that, could have changed.
Some of the things that we haven't talked about, one of them is philanthropy. There are lots of ways that people want to be charitable during their lifetimes, but also upon their death. And there's some really creative tax strategies to be deployed in various documents. Or, if you are interested in leaving behind material gifts, either for tax reasons or just because you love a certain organization and feel passionately about what they do, those things should be looked at periodically. Another reason to potentially look at these, it may not be a birth or a divorce, it might be a move. If you're a resident of New Hampshire and you move to Iowa, the laws in different states will be different, and typically you want an attorney in your either state of residence or at least barred in the state of residence so that they can help you, because while the federal laws are basically the same, state laws vary a lot, and you want to make sure that you're up to date. There's also the possibility that there's major legislation, in one case, HIPAA legislation changed the way health directives were handled in a year, or estate tax limits are changed, and so new planning is needed, plus or minus. And a lot of that onus, Amanda, I think is on us as advisors to let our clients know that that's an issue. But if you don't have a financial advisor or an active relationship with a lawyer, and you're not sure how to be on top of that, the tea leaves aren't always obvious. Beneficiary designation, same thing. Coordinating them with your financial, your philanthropy, your legal, your estate documents matters. Business and real estate succession plans we talked about. The business succession plan especially is really important, because what might have started as a hobby and now has turned into an organization with 15 employees, they have to be treated very, very differently. Real estates, we talked about those things. Let's talk about digital assets. And people hear digital assets, and sometimes they're thinking about, cryptocurrency. But there's also things like patents and trademarks and protecting and understanding passwords and access to various accounts. What is the best practice around intellectual property in that regard?
Yeah, I mean, also what can be included in digital assets is like your Facebook account, your email.
Yeah.
So, most of the states, I think, passed laws in 2020 regarding. There was a lot of things that went on in 2020 in the estate planning world. There was the Secure Act with retirement accounts. There was Digital Assets Acts that allows for your executor or whomever to be able to access your digital, accounts and passwords. As far as for like copyrights and trademarks, those should be, included in your estate planning if you have those. As far as like your other digital assets and like what you have and how to access them, I mean, one is cryptocurrency. That's going to depend how you own it. If you own it in Coinbase or something like that's a little bit simpler. If you actually have like the key seed phrase and that kind of thing, that's another conversation to
Yeah.
have. But for digital assets, I mean, some of the information we provide our clients with is we provide them with like worksheets about your assets, and is to like make a list. Make a list. I have these bank accounts. I have this life insurance policy. These are the beneficiaries. It's a good exercise. We have a
Yeah.
simple one for digital assets, like these are my passwords, da, 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 da. And you should look at those things. You don't have to use like templates we make. There's like accounts online, or you can keep it somewhere else, but it's a good idea to have a list of all that stuff. It's a good exercise to do to see what you have, and then, look at that each time you're looking at your planning to make sure it's still correct and you haven't created a new account or something like.
Yeah, no, I think that's good advice, and when it comes to passwords, I think using a password keeper and then having that master password secure such that, if someone can gain access to that legally upon your death or your, incapacity, they'll wind up with sort of that full bank of access to the various sites and go start shutting things down. It's really an enormous task, and there are estate administrators, administration companies that will help with some of that. I know some lawyers will do that kind of work, and it is tedious stuff. I mean, just shutting down the utility bills for somebody who's passed away can be an enormous task. So
Credit cards,
there's a
credit
lot of that. Oh, credit card, all of it. The banking assets, I mean, Comcast wants to still get paid for a long time. They make it difficult to even cancel that. So all those things. Um, we said here review every 2 to 3 years or after life changes. At the end of the day, every financial plan that we do, Amanda, has a full list of beneficiaries, primary and contingent, from every account that have been verified. It has every asset listed with the title of those assets. And it's got all the responsible parties listed on all the various documents so that we can step in if somebody calls and say, hey, what do we do? Mom passed. We also do, and I don't know if your firm does this, but we do an information sharing piece which will allow our clients to name one or more people with whom we can share information, even though they don't have the ability to transact anything. So if they said, mom's been transported to a nursing home, does she have long-term care insurance? We can answer that question because we have the written authority to do it. And I think that's a good step to take too, just for starters, to say, yes, your mom has an insurance policy with XYZ insurance company, and here's what to do. Um, ultimately, if you're that person in the household who's handling everything and you have a spouse or family who's not particularly interested in that, which does happen, they just need to know who to call. Who do you call? Who's the financial advisor? Who's the tax advisor? Who's the lawyer? Maybe who are some other key people in your world? And maintaining that, I think, is really, really important. Anything to add before we go to Q&A?
No, I was just gonna say we do offer similar services there. We have,
Yeah.
clients sign off that we can share their documents or, some limited information with people if they contact us and something's happened. We also actually have an ongoing legal services plan where people can, have us kind of on call, and we at least meet annually, but it includes meeting with your family members, your financial advisor, if you do pass away, meeting with your beneficiaries. It's all
Mm.
included with the plan, and we have that. We've met with you annually, so we know what's going on, currently, rather than, we did your planning 10 years ago and we're not sure what's happened
Wow.
in the interim.
That's actually a great service, and I haven't heard of other firms doing that. So either you're an incredible trendsetter or everyone else is keeping it a secret. One or the other. Maybe both. But I no, but I love that. So on your screen, you have our contact information. By all means, call or email us anytime. Sarah, what's in the queue? We have about 6 minutes for a handful of questions, and we may not get to them all today. And if that's true, we'll just ask folks to email us, and we'll do our best to answer them after the fact.
Yep.
Yep, we have some questions.
Great.
One, I have a will somewhere from years ago in a different state. I don't remember what it contains, but I do more recently have a trust. Do I need to track down the will and delete it if it might be in conflict?
That's a great
So
question. I'm going to give you first stab at that for sure.
So that sounds like there's both a will and a trust that exist, somewhere out in the well, the trust we know about, the will is somewhere out in the ether. I would certainly recommend usually a will, play off the trust. If it's a revocable trust, there's different types of trusts that, are less common. So I would uh, if you can't find it, and especially if it's in a different state and it's old, I would just go ahead and contact an estate planning attorney to have a new will drafted. They can make it, they can update whatever the will needs to say in order to, incorporate the trust. The trust doesn't necessarily have to be changed at that stage, unless there are other changes you want to make. You definitely do want to have that will in place. Although most everything might be handled through the trust if you have it properly funded and have beneficiary designation, you're gonna need that will. It's gonna be needed for like a refund check, a final paycheck, someone to, file your final taxes, whatever it is. And wills, most documents you can work off copies. People will accept copies. A will, you always need the original. So even if you have access to your will and you don't have the original, you should probably get it updated.
Good advice, and I do think if you've moved, and clearly you have, having a will and powers of attorney and health directives that are in your home state, your current state, matter anyway. So whether you could find the old will or not, I think it's really important to do a new one, and it will supersede any prior. It will say last will and testament supersedes any prior document. So if someone finds it and presents it, it will be thrown out. You may also want to check with the register of wills in the county or municipality where you lived in case the attorney that did your will last time filed it with that registry, and I think, every county in Maryland I know has one of those, but I don't know what state we're talking about, of course, but, you may either go back to the attorney who did it, who may have that will in their vault, or you may wanna check with the register of wills, and otherwise, if it's truly lost, you just make sure that the new one you do in your home state says, "This takes the place of any prior document, supersedes it, and renders any prior document moot." What else, Sarah? Good question.
Um, for one person, they have a godparent for their kid. How does that differ from anything that you guys have talked about, and is that enough?
I
I
generally
don't think that's legal.
It doesn't have any legal bearing.
No, mm-mm.
Usually that's a cultural or religious, type designation. So it wouldn't if the godparent if the intention of the godparent's going to be the legal guardian, then they should have that drafted, within their documentation.
Yeah, that is you if that's the person you're gonna name to be guardian or trustee or attorney in fact or healthcare agent for your child, that needs to be reduced to writing because that will not qualify.
There are ways to create estate plans like online with some tools, and then there's estate planning attorneys and advisors. At what point is it okay to use the online tools, and at what point do is it really important to hire a professional?
Well, I know Amanda's got an opinion on that. I do too, and this is the last question we have time for. Do you wanna take first stab at that since that's in your
Sure.
backyard?
Yeah, I mean, generally for the most part, I don't recommend the online tools. And the primary reason is it might create a valid plan, but that plan might not do what you want it to do. And that's probably the biggest danger I've seen, with the online plans. Some of them not valid at all. I won't name it, doesn't even name a governing law. Another one, I won't name it. They don't. They'll put what you say. In place, but it doesn't necessarily translate correctly. I've seen people draft them on their own where I was like, okay, everything's going to your children. Is that your intention? No, I wanted it to go to this person, my spouse first. And I'm like, well, that's not what this says. I've also seen ones where people have it drafted, and then they have it signed, and it's not signed appropriately, where it's not even a valid document. Because when you do an estate plan with a professional, it's going to they're going to sit down with you and make sure it's signed correctly with the proper witnesses, the notary, any other self-proving affidavits, and that type of thing. And I will tell you, estate planning people think, oh, I can only do this if I have X amount of money. That's not really true. We we offer a lot of different options. We have our prices online, and there's a lot of different price points. And it's really much more affordable than people think. Um, to do it with a professional and get it right, because it's going to cost a lot more time and money if you don't.
What I will say is I do know of some online services that are in fact legal and reputable. I don't recommend that under most circumstances. I think it's better to have legal counsel. I will say it's better to have one of those than to have nothing. But you're always better off with an attorney. You know, we can handle our own taxes, our own finances, our own legal work. I would sooner handle my own root canal. I think it's really important to have a team of people who know what they're doing and can ask some of the tough questions that maybe the software doesn't, and that can also be human. You know, the software might say, "Sure, it's fine to leave that house to your 6 children. Here, sign this." That's not how life really works, and so I do think there's a benefit to not just the human side, but the experience level that comes with having good financial, tax, and legal professionals. So woefully, we're out of time. Amanda, thank you. You made Halloween, well, post Halloween, less scary for me. I hope we didn't scare everybody. There are solutions to all of these things, and you know, Amanda and I would both love to be part of those solutions for you. So, any final comments or thoughts?
No, thank you so much, Eric. This was delightful, and I feel much better. And I think, next Halloween, I'm going to be less scared.
If anyone wants to send me a Snickers bar, I will accept that because I did not, in fact, get one at Halloween. I don't want a lot. I only want one. It seems fair. So for now, we're signing off. Thank you for joining us. If you have further questions, phone or email. If we didn't get to your question, please email us. I'm sorry we didn't. If you're watching this on replay, of course, get in touch with us. We do these webinars on a regular basis at BFG. And if you have a topic idea that you'd like to hear, ping me as well. And I'd be remiss if I didn't thank Hannah Dennis and Sarah Losi for being amazing helpers in pulling this off. Sarah is not on your screen right now, but I can see her and I'm waving and I appreciate you. Thank you very much. Amanda, it's a pleasure working with you. And we hope everybody has a great day and we can look forward to Thanksgiving now.
Thank you to everybody.
Take care, all.
Bye bye.